Добър ден на всички! Добре дошли на днешната ни конференция, посветена на механизма на Европейския съюз за демокрацията, принципите на правовата държава и основните права. Заедно с познати имена в европейските институции ще разгледаме какво предстои от тук нататък, какъв е общият европейски стремеж. Тази конференция се излъчва директно в моята Фейсбук страница на български език. Излъчва се обаче и на английски език, заради големия международен интерес към нея в платформата Vimeo. Получихме много въпроси чрез платформата Slido, но аз ви насърчавам да продължавате да питате, да изразявате своето несъгласие, да отправяте критики дори към процедурите в Европейския съюз, да задавате важните въпроси за вас, българските граждани, защото Европа е нашият общ дом. Ние принадлежим към него. И затова всеки един успех на Европа е успех и за България. И обратното е вярно. Всеки един неуспех за Европейския съюз е провал и за българското гражданско общество. През изминалите няколко години темите, свързани с гарантирането на принципите на правовата държава, с инструментите за върховенство на закона, а напоследък и с обвързаността им с условията за защита на бюджета на Европейския съюз, присъстват все по-често не само в дневния ред на институциите в Брюксел, но и в ежедневието на гражданите. Защо тази тема е важна? Важна е, защото концепциите на правото на Европейския съюз, дори да звучат абстрактно, съгласно член 2 от договора за Европейския съюз, който казва, че общият ни съюз е основан на споделените ценности, на зачитането на човешкото достоинство, на свободата, на демокрацията, на равноправието, на правовата държава и, разбира се, зачитането на правата на всички граждани. Това включва и правата на малцинствата. Тези ценности са основата на всичко онова, което ни обединява. Ето защо на систематичните и тежки нарушения на общата ни ценностна база трябва да се гледа с нужната сериозност, обективност и, разбира се, основан на доказателства прочит. Макар че член 7 от договора на Европейския съюз установява два механизма – превантивен и санкционен, за защита на ценностите на Европейския съюз в случаите на системни нарушения, опитът от задействането на процедурата показа, че тя е особено тромава, а изисква висок праг на приемане на решение. С цел да се засили спазването на принципите на правовата държава и с цел да бъдат гарантирани изконните права на всички европейски граждани, бяха предприети редица инициативи. Няма да се спирам много задълбочено на тях, защото професионалната дискусия ще бъде плод на разговори през следващите месеци, а и нашите високи гости ще направят своите заключения и ще изразят своите позиции по така важните въпроси. Накратко, Европейската комисия и съвета създадоха през 2014 година рамка за върховенство на закона, състояща се в структуриран диалог между комисията и държавите членки и годишни диалози за обсъждане на въпроси, свързани с върховенството на закона между националните правителства в рамките на съвета. Не е тайна за никой, че големия проблем при намирането на консенсусни решения не се крие в Европейския парламент, нито той е в Европейската комисия, а трябва да бъде търсен и намиран в Европейския съвет. За нас обаче, представителите на Европейския парламент, тези мерки не бяха нужното решение, предоставящо равноправна роля на институциите и адекватна превантивна защита в случаите на систематични недостатъци в една или друга държава. И в предходния мандат неколкократно настоявахме за създаване на пакт на Европейския съюз за върховенството на закона, демокрацията и основните права. Този пакт в средите на Европейския парламент е познат като така наречения DRF пакт. Така се стигна до лятото на миналата година, когато Европейската комисия представи в своя нарочно комунике визията си за развитие на този процес. А именно, Как да се насърчи културата на правовата държава? Да се задълбочи наблюдението за спазването на принципите от една страна на правовата държава и от друга да се очертаят позитивните, а и негативни тенденции във всяка една държава. За да не изпаднем в случая да бъдат разглеждани една или две държави или да има избирателен подход, Европейския парламент, подкрепен, разбира се, от Европейската комисия, цели да насърчи един хоризонтален поглед върху върховенството на закона. И тук се стигна до идеята за ежегоден доклад на комисията за върховенството на закона. По този начин Европейската комисия дава ясен сигнал за това как вижда процесите и как очаква да отговори на безспорно важните предизвикателства пред европейските граждани. Всички ние сме съгласни с тази констатация, че върховенството на закона е предизвикателство, което трябва да бъде отправено към европейските институции. Всички сме съгласни с тезата, че закона трябва да бъде пазен и правото трябва да стои като важен, един от най-важните, да не кажа най-важният приоритет за европейските институции. В края на изминалите месеци и по-конкретно през септември Европейската комисия публикува първия си по рода такъв доклад. Той беше широко обсъждан, както в европейските институции, така и в държавите членки. Докладът се основава на анализа на независимостта и ефективността на правосъдната система, на мерките с борба с корупцията, свободата на плурализма, на медиите и други институционални предизвикателства. Този доклад Европейската комисия се надява да бъде база за широка дискусия с националните парламенти, власти и гражданското общество. В този смисъл аз възприемам нашата първа среща като първата и много важна крачка към едно такова обсъждане. И за това провеждаме и днешната дискусия в светлината на върховенството на закона и основните права и свободи. Но нека да спра до тук и да не ви преразказвам целият механизъм на вземане на решения в Европейския съюз, нито пък имам за цел да преразказвам позицията на Европейския парламент, още по-малко на Европейската комисия. И точно тук е момента да благодаря още веднъж на нашия комисар, на либералния комисар Вера Юрова, на заместник-председателя на Европейската комисия по ценностни и прозрачност, която, за съжаление, се наложи да отсъства днес, но ни изпрати своето видеообращение. Нека да чуем Вера Юрова. And now let me move to our panel discussion. As you know, during the plenary session just passed, the European Parliament voted in favor of its own initiative report on the establishment of the EU mechanism on democracy, rule of law, and the fundamental rights. And I want to start with Adrian, actually. So, dear Adrian, as the chair of the Legal Affairs Committee, I feel it's most fitting that you address broadly, speaking judicial independence, as the report underlines that every national court is also a European court. And in our work in the jury committee, we stress the need for protection and separation of powers and preventing political interference in the judicial systems. So, Adrian, the floor is yours.
Thank you very much, Ilham. It's always a pleasure to be with you and to be in any event organized by MRF, one of my best friend parties, I would say, and you are one probably of my colleagues which I whom work better in the house. So thank you again for being here. It's a privilege also to be surrounded with such relevant speakers, and also to have the opportunity to have these exchanges of views on one of the core principles of the European Union, which is today also one of the main challenges we face, which is the rule of law. Although I'm young, I still remember when I started my career in international institutions that the rule of law was basically taken for granted, at least in Western Europe. Also, the treaties foresee mechanism of Article 7, like you just explained, to sanction breaches of the core principles of the Union. And I'm certain that for decades, nobody will have seriously considered that this or other kind of mechanisms will be necessary at some point. But now it is. Unfortunately, here we are. For some years, We have witnessed illiberal processes in different European countries that have put at stake some of the most important elements of the rule of law. Moreover, the mechanisms we never wanted to need have proven to be ineffective and clearly insufficient to prevent this guise of illiberal reforms. The rule of law provides modern society with a key defense against the arbitrariness of power. If we, the people and the institutions of the European Union, fail to set up an effective strategy to protect the cornerstone of our rights and freedoms, even the most democratic and civilized country can fall within the abuse of those who have the power. The Parliament is doing its job by demanding the Commission to come up with a proposal for a new mechanism on democracy, rule of law, and fundamental rights. And I have to say that the excellent cooperation within LIBE as leading committee and JURI as associated committee is a good example of it. And I want to take this opportunity also to thank Chair López Aguilar, who is also a Spaniard, for this fruitful cooperation that should serve as an example on how this Parliament gets results when its different bodies, its different committees, and moreover, its different political groups work together for a common goal. At this point, I would also like to stress that the Legal Affairs Committee will follow closely the impact of this initiative report on the works of the Commission and in the future legislative initiative that we hope to receive in the Parliament as soon as possible, also as Ilhan explained right before me. Within this framework, let me remark the relevance of some topics that the committee that I chair touches upon. The committee covers the union legislation regarding civil and commercial law, company law, intellectual property law, and procedural law. None of these areas of the law can work properly without the guarantee of an independent judiciary in the civil and commercial jurisdictions. As a result, the effectiveness of the future mechanisms when it comes to assessing this independence, monitoring any eventual violation of the independence, and providing with tools to sanction and correct those violations will be definitely a priority of the JURI Committee. I am certain also that this Parliament, as well as the EU institutions, will be vigilant with those national governments proposing reforms to put the judiciary under political control and do everything in their power to prevent this from happening. That is why any future mechanism that is set on play should keep this objective in mind. Last but not least, let me put the focus on the diversity of tools that the European Union can count with to protect the rule of law. Within the JURI remit, we will firmly defend a mechanism able to monitor and ensure aspects such as independence of the legal profession, duration and cost of litigation, adequacy and effectiveness of the legal aid system or existence of the necessary funds for legal aid. We will also put the focus on the judicial training and the improvement of the EU justice scoreboard, with special regards to ensuring the independence, impartiality, quality, and efficiency of member states' courts and judges of the civil and commercial jurisdictions. These things that I just mentioned sound that they're obvious, but nowadays they are not anymore. Finally, the discussion on this future mechanism should include a debate on the role of the European Court of Justice as the highest guarantor of the rule of law in Europe. Any kind of legislation aimed to protect this fundamental value could be useless if we do not have an empowered European Court with clear and well-defined functions concerning the application of this mechanism. The debate on the future on the rule of law in Europe concerns all of us. No true Democrat can remain indifferent to the threats to this core principle of our union, this cornerstone of our democracy. Because as John Locke said, wherever law ends, tyranny begins. And it's our responsibility to raise our voice when we see that these violations are happening. Thank you very much.
Well, thank you, Adrian. Thank you for making very clear points. And also thank you for quoting one of my favorite philosophers, John Locke. And we'll come back to you in the Q&A session. But now I want to move to Sophie. And Sophie Infeld is a very known politician in Bulgaria already. And Sophie, you were a rapporteur on the first EP report for creation for DRF Pact last mandate. And you continue to observe what is happening in the member states as chair of Democracy, Rule of Law, and Fundamental Rights Monitoring Group. You have been vocally insisting that EU mechanism should include not only the rule of law, but also insisting on freedoms, also insisting on fundamental rights. However, according to ECG, the EU is a community based on the rule of law, identifying this concept in its practice as including legality, legal certainty, prohibition of arbitrary use of power by the executive, effective and impartial judicial review, but also fundamental rights and equality before the law. So why is it important that the monitoring also cover fundamental rights? Sophie, the floor is yours.
Thank you very much, Ilan, and thank you for organizing this and inviting me, because it's indeed a topic that is very dear to my heart and has been for a number of years.
Голямо значение вече няколко години.
Okay, I may be on the wrong channel because I hear the interpreters. How do I switch channel?
From more language interpretation, and should be English.
English. Done.
Yeah.
Okay, now it should be better. Sorry for that. Yes, almost 6 years ago, our group, the then ALDE group, took the initiative for a seminar where we presented our idea for at the time, a scoreboard for democracy, the rule of law and fundamental rights. And it's actually quite funny when I remember how that went. We organized it, and we had prepared a kind of scoreboard with green, yellow and red scores for all the countries on a series of indicators: independence of the judiciary, freedom of the media, equality between men and women, protection of privacy, everything. And this was just, a political group presenting its own makeshift scoreboard. But it was taken very seriously by the member states, because I remember a few days before we were about to present it, we started to get phone calls from the perm reps in Brussels who were getting a bit worried about, how does my country look in your scoreboard? And eventually we decided to take the names of the countries off the scoreboard because people were getting very, very nervous. And that to me showed that even the fact that all the countries are assessed on the same basis has an impact. I call it the Eurovision Song Contest effect. Namely, everybody thinks the music is shite, but nobody wants to be last. And you've also seen it with now that the actual report, 6 years after we made the proposal, the actual report now exists. And some people are dismissing it, saying, oh, it's just a report. But if it were only just a report, then explain to me why some member state governments got so terribly upset about it. So it has an impact. But clearly it is not enough, because it's not worth anything if we don't also at the same time have not just the tools, but also the political will and the political courage to pursue breaches of our values. And yes, we want the full scope of Article 2 of the treaties, all the values of the European Union: democracy, rule of law, fundamental rights, because they all go together. They cannot be separated out. And I think it is useful to remember, I always like to point this out, that Article 2 is by far the most important article in the treaties. Not Article 1, because that just says, hello, everybody. Article 2 is the values. Everything else, internal market, transports, fisheries, police and justice cooperation, comes after. So this is, the foundation. And this is also why we have the famous Copenhagen criteria, which determine the standards that member states or aspiring member states have to meet before they can join the European Union. And it's clear we need to uphold those values once member states are in. Now, we have the report, we have Article 7, we have infringement procedures, we have a range of monitoring tools. But I think what is lacking is political courage and political will. For example, if I see that the European Commission has started several infringement procedures against Poland, but then fails or actually refuses to see it through. When I see that the Council, is just too shy to tackle the Article 7 procedures against Hungary and Poland, when I see how the EPP in particular, a little bit like the Republican Party in the United States, is gradually, being consumed by the populists and is refusing to recognize that some of their parties, like their Bulgarian EPP party, the Hungarian EPP party, are basically no longer representing the values that EPP used to stand for. But this goes, look, every party family has its awkward cousins. Let's not be shy about that. We have our awkward cousins as well. The question is, yes, Sergei, the Greens do too. I'm sure of that. We're all human beings. So that's not the question. The question is, how do you then deal with it? And if we do not have the courage, like what we see happening in the United States is basically the direction we are going in as well. If we don't take steps, if we do not have the courage to tackle those problems within our continent, within the European Union, within our own political parties, if we are afraid to speak out, if we're afraid to criticize, if we're afraid to penalize bad behavior, if there is impunity for breaking the rule of law, if there's impunity for corruption, if there's impunity for authoritarianism, if there is impunity for threatening journalists, then those phenomena are going to grow at the expense of the liberal values, the liberal Democrat values that we all stand for, small l. So I would like to urge everybody in conclusion to make this a political topic also in the political campaigns, even in election campaigns that we are conducting, because if we don't stand up for those values anymore, I mean, we cannot outsource the protection of those values to courts or to journalists who are uncovering corruption, or to demonstrators or NGOs or individuals who go to the court. If we ourselves are afraid to climb the barricades and speak up for what we believe in, even if it is against some of our own, then we're going to lose it. So I would argue very, very strongly for political courage and defending democracy, even if at times it's awkward. Thank you.
Thank you so much, Sophie. I agree with you. It has an impact. We made a first and important step, but we shouldn't rely on the first step. Certainly, it's a good initiative, but we should continue. And I would like to thank you once again that you took the initiative and you decided to cooperate more with the national parties. And I know my party is going to give you a name who is responsible for rule of law and fundamental rights package. And now I want to move to the three rapporteurs, the main rapporteur, the EP rapporteur, Mihail Simechka, Vladimir and Sergei. You are respectively the EP rapporteurs and rapporteur for the mechanism, and also you are representing EPP and the Greens in the European Parliament. And the European citizens, frankly speaking, are getting lost in this Brussels language. A report on the Commission, a week later, a report on the European Parliament, and trialogue on rule of law, conditionality. Vice President Jourova touched on this briefly when she said we didn't hear her presentation, but I have her overview. She said that we differ in our approach, but our aim is to strengthen the rule of law. Could you address the differences in positions and significance of the interinstitutional agreement for this process? And I would like to start with Mihail as EP rapporteur. Mihail.
Thank you very much, Ilhan, and hello everybody. And thanks so much for putting this together and for fighting for the rule of law. And it is indeed a pleasure to be here with so many distinguished speakers. And I will definitely want to answer your question. And I also understand that there are lots of people, and also people in Slovakia and citizens and voters, that are sort of wondering, there are all these instruments and all these institutions, all these tools that are being used about the rule of law, and people are getting lost. I want to touch upon that, and I want to say that, and I want to argue that the report that the European Parliament has voted for last week with an overwhelming majority, the report that we prepared with our fellow rapporteurs, is precisely meant to clarify the situation, to consolidate, to put it all under one roof, and make it also a bit easier to understand for everybody. But before I get to that, I just wanted to touch upon one thing which Adrian started, and I think I would like to pick up on it. On why is it so important? Not just for defending rule of law, all that. Also, Sophie talked about the kind of courage we need. It's of course because of the values themselves, and because of Article 2, and because of the protection of rights for every citizen. But I think, and this is kind of my concern as well, that this is also critical for the very survival of the European Union as we know it, and in practical terms as well. The crisis that we're in, kind of the rise of authoritarian and oligarchic politics in our member states, is not just it's not just bad to look at and distasteful and threatening those countries and their democracies, but threatening the European Union, which after all is based and functions because each member state has a trust in the rest, in the fellow member states, that they are democratic, and then their institutions, say the judiciary, are independent, and that their leaders are elected in a fair democratic process. And this is all that keeps the European Union together, this kind of trust. And if we lose that, this is going to be the beginning of the end of the EU. We can't have a European Union when you have one or two or more member states who are autocracies. That's not going to work. Also, in practical terms, how do you cooperate in the single market? How do you cooperate on internal security, on law enforcement, if you don't trust the other member states that they're not going to abuse those powers and misuse those powers? And you already see it when it comes to the judiciary. You already see that courts in the Netherlands basically are refusing to extradite Polish citizens back to Poland because they are fearful that that they won't have a right to a fair trial in Poland because of the rule of law problem. And this can crumble the single market, which is based on the European Union being a community where law is, and European law is, interpreted in the same way. So this is just to highlight that this is an existential thing for the EU for the future, and this is where our report comes in. The fact that the response of the EU to these trends has been patchy and inefficient is also because nobody has prepared us for this, because the European Union never was supposed to be the body to enforce its common values, because they were implicit. And so we have many instruments, Article 7, we have rule of law framework, we have the rule of law dialogue in the council, we have obviously CVM, as people in Bulgaria well know, we have the justice scorecard.
Michael, can you hear us?
Yeah, I'm sorry. Did the whole Zoom fall, or it was just me?
I think it was just you.
I apologize.
No problem.
What I was trying to say, and I think with the report, with the contributions that others have made, does very well. It tries to put all the various instruments under one roof. So we have one monitoring based on objective, fair criteria of all member states on rule of law, democracy, fundamental rights, and then that monitoring becomes the basis for action in using all the other tools, but it's all under the same framework. And in the future, then we can, if we have this in place, then we can dispense with some of the other tools that will become redundant, including at some point also the CVM, because we'll have this proper mechanism which will cover everything, and which will be the source of assessment of how member states are doing in the rule of law. And if in this report there are systemic failures, then it would be clear what are the consequences, say in terms of budget, in terms of infringement, or in terms of Article 7. But there needs to be some order in this. And finally, and this is about the interinstitutional agreement, which is why is the Parliament insisting that the rule of law monitoring mechanism is based on an interinstitutional agreement. Of course, even today, we have the Commission coming up with the rule of law report, and you mentioned it, and that's good. But that's partly because we have commissioners like Vera Jourova who actually care about this issue and who are committed to defending the rule of law and the values of the European Union. But this is very, very shaky. I mean, what if there was somebody else in that commissioner's portfolio? What if there will be somebody else 5 years from now? So what we want with the interinstitutional agreement is to put it in legal writing and to have a binding commitment of all the three institutions that this is how it's going to work, and regardless of who is the commissioner or regardless of who holds the presidency of the council, so that it's permanent. And this is also what the Parliament will be insisting on going forward to start these negotiations on the interinstitutional agreement. Thank you very much.
Thank you, Michael, for your comprehensive talks. And I got the point. European Parliament wants to put a bit more order in the House, in the European Union even. And I'm turning now to Vladimir, and he will explain us how EPP can put more order, not only in their family but also in European Parliament.
Good morning, everyone, and thank you, Ilhan, for organizing this and for the invitation. A lot of references to the EPP, and I will certainly get to those. But I think this is mostly European discussion, and I'm very happy to take part. Ilhan, you and I deal often with the Western Balkans, which is our common territory, and I think that's where we really push for change, reform, and also rule of law. But it's clear we have to apply at the very least the same standards towards all of us across the European Union. Now, I'm very happy we are having this debate because I think even the vote in the European Parliament was a real sign of the fact that this matter is urgent, and we have a broad consensus. We need clarity on the rule of law. We need a mechanism which works, which the people, citizens in Europe understand. And I think most of all, and this is really to pick up and also to support Michal Šimečka's words, and I want to thank also here Michal for his work as the rapporteur, but also for his cooperation. I think he approached the issue not just technically, but also politically, in a sense that he wanted to have the widest possible support for this, because I think we send a strong signal as members of the European Parliament to the other institutions that we need a joint ownership of this mechanism. We need a joint ownership of strong monitoring, preventive measures, diligent approach to rule of law issues by all EU institutions. So in that sense, for me and for us, what's important is to have a legally binding rule of law mechanism. I think this is the key. And, you know, we actually had a discussion before the vote about the nature of Michal's report. Should this be a legislative on initiative report, or should this be a non-legislative on initiative report? And we all insisted this must be a legislative file. We have to really push the Commission and member states to take this seriously. This is not about playing games because it divides all of us. And I agree with Sophie that we all have smaller or bigger problems in all of our political families across the European Union. And if we keep on naming and shaming, picking and choosing different countries, different problems, it's not going to be helpful for the project as a whole. We need to always push when we have problems. I think we need to have a mechanism which deals with these problems in a way whereby we understand when we have a problem, we know how to address it. And we don't have that at the moment. And this is the goal of what we are trying to look at. It is a real move from years ago. The Commission published its own reports on its own initiative, essentially this year. But that's not enough. We see that is not enough. We need more. We need a mechanism which is going to be diligent, but also fair with respect to all EU member states. Here I just want to say very clearly, in terms of my political family, which is the largest one in Europe. I think we need to make sure that we remain the largest force in Europe, and that's why we have some housekeeping to do. Had it not been for the pandemic, we would have made some important decisions already last month in the EPP. That's very clear. And as soon as the pandemic is over, we will be making important decisions on our own future. So we are not keeping things go by or being idle about things, but we are engaged in very serious discussions in terms of how we can also resolve our internal problems. And just for myself, just like in the European Parliament, also in other capacities, I will always stand by the principles of the rule of law. And I think that is important, and it's also essential for our common European project. This was an important exercise we had in the European Parliament, but it's the beginning. It really is the beginning. And now we have to push hard that we have a real move by the Council and the Commission. We really have expectations with respect to the German Council presidency. It is a difficult context because of the pandemic, because of the wider budgetary issues which are being discussed. But I think we need to really push on this front. Just like in the context of the COVID-19 situation, where we are facing a number of pressures on our democratic institutions, it's very clear it would be helpful to have a predictable rule of law mechanism which would work in the benefit of all of us. Maybe last point, and this is what I want to underline, is that this rule of law mechanism should aim to strengthen the existing EU institutions. I don't think we need to invent a new wheel. We need to invent parallel structures. We need to make sure that the Council, the Commission, the Parliament, and the Court of Justice are much more committed to taking the rule of law issues seriously. This is the whole point. I don't think it's going to be helpful if we engage other new mechanisms on this unless there is real political seriousness of the institutions which are here tasked with not just making the rules, but also following the rules. And I hope that message from the European Parliament, from the political groups, which was very clear in the vote on the Šimečka report, will be taken equally seriously in other institutions. My sense is that we have only a few shots to get this right. And perhaps this shot is the one that should be taken seriously, because time's gonna run and the problems will only pile in a number of member states. And so I really welcome this initiative that you put together, Ilhan. And I also welcome the fact that this is not just a single political group or family doing it, but we have a chance to have a wider exchange. I think it is important on these issues, because I think we all may have different political differences, different style in terms of how we do politics, but I think we all respect the same principles, and this is important. So thanks again. I'm happy to engage in a Q&A.
Absolutely. You'll give a chance. I'll give you a chance to engage later on. And I want to start by quoting you. We need a mechanism which will strengthen and which could strengthen the European institutions. We need a fair and diligent approach when it comes to the future EU mechanism. Very strong and important words. And with that, I want to move the discussion to Sergey and the Greens, how they see the process and what they can do to strengthen the European institutions.
Yeah, well, thank you very much. And colleagues, it's great to see you outside the usual committees and groups in a different setting. Important topic. Thank you, Ilhan, for your initiative and for your leadership on that. It's a shame that Madam Commissioner was not present, and it's a shame that we didn't hear her. And to be honest, as I wrote in the chat, I think it's a little bit symbolic. I think that this commission, with all due respect and with all the support that we express also to Ms. Jourova when she's being attacked by Orban or others, which is a sincere support, I think that this commission has lost its ambition and its drive, and I think it's up to the parliament and to us to keep the flame going. Because what I see now and what I saw with the report, which is generally, of course, with the report of the commission, which is generally, of course, something which is positive, but it was a report lacking two things, lacking a political ambition on the one hand, and lacking persistency and consequentialism on the other hand. I'm afraid that we underestimate the degree of frustration and degree of disappointment in the field by the affected organizations and civil society that is resulting now, and which is addressing and which is targeting no more Orban's the PiS government. I don't want to focus on specific governments. We don't need to name and shame here in this room, but we know who we're talking about. The frustration is increasingly pointing at the Commission, and I want to protect Commission from those consequences, because we don't want a situation where the credibility of Commission will be deeply damaged in this area. And that's why I would have wished that Commissioner Jourova were here in person, and just as we do with Mr. Reinders, we discuss this directly. I think the only way to go now is not just naming without even sometimes shaming, just like the Commission has done it in its report, but it's naming, it's suing, and it's following through. Without these three steps, we will not be able to produce results. And I think that a proposal that Michal has made with our wholehearted support is an important step towards that. Why? Because first of all, and as he mentioned, as many mentioned, it consolidates the field. By now, I'm thinking, you know, I maybe maybe it's too evil of me to think this and to ascribe this, but I see a strategy of confusion and proliferation of mechanisms and tools. We have by now too many tools that address too many different segments, and citizens and affected governments can feel safe because they know, that the Commission report will only address this part, and the peer review of council will only do that, and the justice score will only address it, and then it will disappear in the nirvana. And this is not the way to go. And what Michal is proposing in his report is exactly right. Let's put this thing together. Let's make it systemic and a systematic overview based on all three institutions being engaged. It has to be all encompassing. And this is, of course, a topic dear to the heart of Sophie, of Michal. I think of our APP friends as well. It cannot be limited only to rule of law. This is a general problem, which we also see with the mechanism proposed by the German presidencies, a huge problem there. We are talking here about Article 2, and Article 2 involves values beyond rule of law. What do we need independent courts for if those courts have no fundamental rights to secure? And this is another important point of the report that we as Parliament are proposing. From our perspective, the report also, and the mechanism as proposed, gives the process two things that we need. On the one hand, political ambition, and on the other hand, credibility. How? Credibility is given by the panel of experts, which will be involved on the side. It shows that even though the process is politically ambitious, it is still based on expertise. And this is part that was important also to us, that it is about also expert opinion, which is involved in the process. About political ambitions, I think that the political ambition in this whole structure can come only from the parliament. And what we have been seeing for months and years by now is that parliament is being shut down in all those processes. Look at Article 7, which the parliament has launched and where the parliament doesn't play any role in the procedure. But we see this with the report by the Commission. If only the Commission it is who is launching and pushing the monitoring, or if only the peer review is done by the council, they structurally cannot develop the political ambition that the parliament can bring into the process. And that's why it's important both expertise of experts to bring credibility and the passion and the political ambition of the parliament to move things forward. And this is what the report of Shimika is proposal, and we of course support it very much. And number 3, and finally, no monitoring cycles and no reports of commission will be effective if we don't have consequences and effectiveness. So this consequentialism is something that is lacking with most of the instruments that we have seen so far, and something that the report of the parliament is addressing explicitly. There should be consequences. And how do we see consequences? For now, those consequences can be legal, or those consequences can be financial. And unfortunately, on both fronts, we are now seeing huge problems. I'm not going to talk about the conditionality issue. I mean, this is not the point here, but of course, the offer proposed by the German presidency is something that, from my perspective, and I think from the perspective of most political groups so far, is not something that we can agree for, because it basically kills any credible mechanism of enforcing the consequences out of such monitoring mechanisms. And to be honest, on the legal side, with all the procedures, and Sophie mentioned a couple that have been either not launched. Sophie, remember our fight, or Mr. Bill, do you remember our fight in the group during the COVID times, when we were pushing the Commission again and again and again, do something in terms of reviewing the measures, the COVID measures in Hungary, for example, where we were pushed back again and again. And of course, you can say that didn't materialize. But what we have seen is the hesitancy and non-consequentialism on behalf of the Commission. And this is something we have to break through and to change. And it doesn't mean that we don't cherish and don't respect the efforts by Reinders and Jourova and von der Leyen and others. But we need to bring fire into the game, because otherwise this fire is going to extinguish. And when we see how things are developed now with Morawiecki, with disciplinary chamber, where the Commission has achieved something in terms of the ruling of European Court of Justice, but does not follow through on it. And what we see is now the consequences, just as we see the consequences of NGOs not getting grants in Hungary, just because they are labeled on the basis of something that was proclaimed illegal. We need to follow through, not just to start suing and to start procedures. And this is something that we expect from the Commission, and I do hope very much that we get an actual discussion with them, not just by addresses that we don't understand and cannot hear, but in actual exchange with the commissioners. And I hope that we join forces there, because I think that we all are united by our common vision of how rule of law mechanisms and rule of law state of the Union should look like. So I'm looking forward to our discussion, and thanks for inviting me, Ilhan. It's a great privilege.
Thank you, Sergey. The privilege is mine. You made a lot of valid points, and as we had a technical difficulties before, can we give another try to Commissioner Jourova's message to us before and the actual discussion?
Ladies and gentlemen, unfortunately, I cannot join you live for this important debate, but we are fortunate to still be able to convey messages via digital recording. I would like to thank Mr. Kyuchuk for organizing this event and for raising awareness to the importance of defending the fundamental values of the EU. It is essential for us to move the debate outside Brussels and engage with citizens and parliamentarians across Europe. The countries from Central and Eastern Europe joined the European Union not only to access the single market, receive EU funds and enjoy free movement. They also joined the European project because after many years of communism, we all wanted to live in free societies where no one is above the law and where fundamental rights are guaranteed. These values are enshrined in Article 2 of the Treaty on European Union. They include human dignity, freedom, democracy, equality, the rule of law, and respect for human rights. The rule of law fulfills a special function among this list, as it guarantees the protection of all other values. History has taught us that democracy needs the rule of law and freedom of assembly and of speech to ensure citizens' control of the state and elected officials. During the last years, the Commission has gradually developed and used a variety of instruments to address rule of law challenges, including infringement procedures and the Article 7(1) of the treaty. We have also worked with Bulgaria and Romania under the CVM mechanism to advance justice reforms and strengthen the fight against corruption. Last year, the President of the European Commission, Mrs. Ursula von der Leyen, committed to respond to launch an additional comprehensive rule of law monitoring mechanism covering all member states. As part of this new mechanism, the Commission presented on the 30th of September the first annual Rule of Law report. The European Rule of Law mechanism will serve to deepen dialogue and joint awareness of the rule of law throughout the European Union. It is a yearly process during which we aim to prevent problems from emerging or deepening, notably by having open debates and by exchanging best practices. The report covers both positive and challenging developments in our Union, including a country-specific assessment of all 27 member states. It covers 4 areas. First one, the independence, quality and efficiency of justice systems. The second, the anti-corruption framework. The third one is about media pluralism and media freedom. And the fourth, other institutional checks and balances. All member states were treated equally, as we applied the same methodology to all and constantly ensured consistency. And I would like to thank the members of the Parliament participating in this discussion for their tireless efforts to promote the rule of law. While we may not always fully agree on the exact instruments needed, we certainly share the same commitment to strengthening the rule of law in the EU. Through the European Rule of Law mechanism, we want to achieve a true dialogue at EU and national level with the European Parliament, the Council, national parliaments, as well as European and national stakeholders. In addition, the Commission will adopt a new strategy for the Charter of Fundamental Rights, as well as European Democracy Action Plan. It is our mission to make this rule of law mechanism a reality so that it can be a real pillar for the protection of our democracies. Each citizen deserves to have access to independent judges, to benefit from free and pluralistic media, and to trust that their fundamental rights are respected. Only then we can call ourselves a true union of democracies. Thank you, and I wish you a fruitful discussion.
Well, not the best performance from technical point of view, but we have tried our best. I think it was slightly better, Sergey, comparing to an hour ago. And I know that Lopez Aguilar is on his way to join us. It's extremely busy day. Sophie has to attend another event, and Adrian had to cover his colleague in Agri committee. And I want to start directly with Q&A session, and I'll give a chance to Lopez Aguilar to make the concluding part. And questions are addressed in Bulgaria, so I'll switch to Bulgarian, and I'll ask you directly in Bulgarian. Interpreters will help us in interpreting the questions. И така, първият въпрос е от госпожа Десислава Апостола, кореспондент на Българската национална телевизия в Брюксел. Госпожа Апостолова казва: Европейският парламент и Съветът на Европейския съюз за сега не успяха да постигнат съгласие по механизма за върховенството на закона. Лидерът на управляващата партия в Полша Право и справедливост Ярослав Качински заплашва да наложи вето върху бюджета и фонда за възстановяване. Ако Брюксел успее да наложи условия за върховенството на закона, готов ли Европейския парламент да отстоява категорично позицията си за обвързването на върховенството на закона и евросредствата, дали няма да направи отстъпление в името на приемането на бюджета и фонда за възстановяване? Кой желая да започне пръв? Сергей или
First,
Владимир?
Sergey or Vladimir?
Thank you. Well, very briefly, I mean, we just passed the report, and of course the negotiations have begun, and we need a solution as soon as possible. But I think it's an encouraging sign that we got to this step. So I think the formation of rules in the European Union also has its natural process. I know we've all said, this is urgent, we need it, but I think we need to give the space and the time to all three institutions to find an agreement. This is not going to be easy. Any negotiation on any interinstitutional agreement in the past, we know, has been a challenge. So I would just allow for a bit of space and time, whilst having inside the fact that in the end we need to have a result. I think this is important, and the process is moving. It has started. We all know the context. It's challenging because of the pandemic, because of the wide negotiations on budgetary issues. And look, we've said in the parliament, and I will certainly stand by it. We need to have guarantees, and we need to have a clarity on the fact that rule of law issues will be tied to budgetary issues. I mean, this is something which I think has been very clear from the side of the parliament, and this is where we really have to push hard. At the same time, we know what the realities are in terms of the decision-making mechanisms. So it is not going to be easy, but I'd say rule of law is a principal thing. It stands above and should stand above politics and political fight. So here there is an extremely important task for the German EU Council presidency, for the Council itself. The ball is in their hands, and I think the message from the Parliament is very clear. We will have our say on the budget, on the financial issues. We will have our say also on the recovery package, and of course, rule of law issues remain central to making a final decision, which I hope will be in the end yes, but a yes with certain conditions which must be fulfilled. Thanks.
Сергей, ако искаш, заповядайки, след което има един въпрос за Михаил. Да.
Sergey, you can take the floor, then a question to Mikhail.
I think, and I agree with Vladimir that it's up to the parliament now to say and to state clear position. The position of the heads of the groups was stated clearly in a joint statement in a comment a couple of weeks ago, and I hope that this remains solid like that. But I think it is important to say one thing. The choice that we are presented with by now the presidency, but also by Prime Minister Orban, is a wrong choice. He tries to present the choice as the one between recovery funds and help for affected regions on the one hand and rule of law on the other hand, and this is wrong. Parliament, we can have both. And this was the initial position of the Parliament. This was the initial position of the Commission and of most of member states. So when Parliament now insists that rule of law will have an effective mechanism, then this is the position that has always been there. And the one person who is trying to hijack this issue and to hijack and take hostage the recovery fund is Mr. Orban and some other governments that support him. And this should be clearly said this way. Not us are hostaging and hijacking the agenda of recovery, but they are hijacking the agenda of the recovery. And this is something that we should not allow to happen. We can have it both, because the European Union is about welfare and about wealth and stability for citizens on the one hand, and rule of law and democracy. And there is no one without it another. And this is the message that the Parliament hopefully will convey very clearly to Orban and other member states who support him.
Добре, има още един въпрос от Десислава Минчева,
Yet another
кореспондент на
question
BTV в
from
Брюксел.
Desislava
И
Mincheva,
той е към
correspondent
Михал
of
Симичка. За
BTV
какви
in
конкретни санкции
Brussels,
ще
to
настоява
Mikhail
Европейския
Simichka.
парламент при
What
нарушаване на
specific
върховенството на
sanctions will
закона
the
и
EP
как е
insist
възможно
in
да бъдат
cases of
наложени
breach of
такива,
the
въпреки
rule of law?
противопоставянето
How
на
can
страни
such
като
sanctions
Полша и
be
Унгария? Подобен
imposed
въпрос към Михал.
in spite of the opposition from countries such as Poland and Hungary? This is a question to Mikhail.
Thank you very much. Thanks for the question. It's perhaps the most pertinent one in all of these debates. I mean, how can we collectively, as a European Union, impose any sanctions if we have lots of decisions have to be taken unanimously, including on the budget, and if we have two countries which are obviously opposing any sanctions regime, any conditionality. Now, they're obviously already in the existing toolbox that we have. There could be sanctions. There's obviously the infringement proceedings against Poland, Hungary, and many other member states. But when it comes to rule of law against Poland and Hungary, and if the European Court of Justice decides that indeed the rule of law was breached in Poland or in Hungary, and if these two governments fail to abide by the ruling, that there will be already financial sanctions imposed, or should be according to European law, and that doesn't require the consent of the Council or of all other member states. That's something that should happen automatically. So there are these financial penalties, but we all know that they're rather ineffective, because by the time the court decides and then financial sanctions are kick in, it takes months, if not years, and by then the original sin, so to speak, is already done, and the power grab is already concluded. So this problem with that is this is small, and also the money is small. Then there are possible sanctions under Article 7, but we spoke about that. We know that they won't ever, under the present constellation, be imposed, because you need unanimity, and the Hungarians will always back up the Poles. What we're now proposing, and this is also what Sergei and others were talking about, is budget conditionality built into the MFF and the new next generation EU, and that's real in the sense that this is real money. That both Hungary, Poland, when we speak about those countries, but of course it could affect anyone, the money from the MFF and from the recovery package is substantial for their economies and for the governments to maintain their power. So this is potentially a real threat. And I think this could be and should be passed, even if the Hungarians and the Poles oppose it. Obviously, they're now threatening to veto it. But technically speaking, you can adopt this conditionality with a qualified majority in the Council. Obviously, you need approval for the entire budget, which is unanimous. But I think they're bluffing, to be honest. I think the Hungarians in the polls, when they say they're going to veto the entire package if there is no conditionality, I think it's a bluff. I think their governments need the money just as much as any other member states which are reeling from the economic crisis, and I think they won't do it in the end. So I think this is the time to be courageous and not to give in to the blackmail of Hungary and Poland. And once this conditionality is in place, then of course it's up to the Commission to determine whether there's a systemic breach in the rule of law in any member state, and if there is, it can withhold payments from the budget and from the Next Generation EU. But what is crucial is that these sanctions, if they ever are applied, are not sanctioning the citizens of those member states, because this is precisely what the Parliament is also insisting, that this shouldn't be a punishment to the citizens who obviously and who and the economy as a whole, which the European Union wants to support, but it should be a sort of a sanction against the governments which are corrupt, which are oligarchic, which are bending the rule of law. Therefore, we propose, and I hope this is going to be the case, that if there is ever a sanction, it's going to be about taking away the control over disbursing this money from the governments, which are problematic because usually they are, disbursing it to their friends, to the various oligarchs and stuff, and instead directing the money straight to the final beneficiaries, such as SMEs, such as municipalities, and obviously, NGOs and what have you. So I think this is how it could work. But first, we have to stand up to Orban and the Polish government at this moment and pass the conditionality.
Благодаря, Михаил. Още два въпроса, които са идентични и бих искал да ги слея. Разбира се, Владимир и Сергей също да се включат. Молбата ми е да отговорят на тях. От Ангелина Пискова, кореспондент на Българското национално радио и от Момчил Инджов, кореспондент на Клуб Z в Брюксел. Въпросът е, сказано в обобщен вариант. Какво влияние би могла да окаже резолюцията за България при обвързването на европейските средства с върховенството на закона за страната ни, въпреки че няма законодателен характер? Нека да поясня. Много пъти българските граждани коментират, не само те, но и анализатори, темата с резолюцията за България, преди това за Полша и за Унгария. И аргументът е, какво прави този Европейски парламент, след като приема незаконодателна резолюция? Какъв е смисъл от това въобще да има резолюция за една държава в Европейския парламент, ако по-образно казано това не следва нищо? Може ли и тримата да кажете по няколко думи по този въпрос?
If there are no steps to follow up, so can you give your opinion about that, the three of you?
Who is first? Can I go first?
Up to you. Yes.
Up to us. Very good. Thank you very much. And of course, we had a discussion on the situation in Bulgaria. We followed the situation in Bulgaria for quite some time. We had a debate. We had the resolution adopted by the European Parliament. And I think the whole point of the mechanism, which the Šimečka report proposes, which we all support, is quite frankly to have less and fewer to spend less time and fewer debates and resolutions along the lines which we adopted in relation to Bulgaria. Because the essence of the question is right. What can the European Parliament do? Well, European Parliament's main role is ultimately to change politics through legislation. We can do a lot of political initiatives. We can have a lot of discussions. We can adopt a lot of resolutions. But unless there is a real follow-up, some of our conclusions might seem politically futile or empty. And in that sense, I find them at times counterproductive. This is why we need to have a mechanism which will assess rule of law systematically, diligently, and fairly in relation to all member states. That includes also Bulgaria. In terms of the follow-up, I think the best follow-up to the situation in Bulgaria will be given by the voters. Bulgaria will have elections sooner or later, but certainly I understand not later than in the spring of next year. And that's why I quite frankly, myself wasn't very happy about the timing of the resolution. I don't think it's an ideal practice when we have resolutions too close to elections. At the same time, I recognize the problems, serious rule of law issues, which Bulgaria has been facing, continues to face. But I think politically, our work also in European Parliament should be such that we are consequential in terms of the commitments we've made in the past. One of those is really trying to help Bulgaria overcome the whole context of the CVM mechanism. That's something I wasn't very pleased with when it came to the contents of the resolution. I think Bulgaria should be treated as fairly, as equally as any other member state when it comes to dealing with rule of law issues. So while I recognize a number of problems which Bulgaria is facing, I also think that Bulgaria is mature democracy in the European family to resolve a number of these issues through elections and through decision by voters, many of whom have been demonstrating in the streets of Bulgaria. And I hope people can make the right choice to also improve things at home at the latest next spring. So basically, this would be my response to not just the resolution on Bulgaria, but also a number of other political resolutions. Now, of course, when we are in a situation when we already have proceedings along the lines of the legal basis, which is the case with some other countries, then I think the European Parliament has to be involved actively as well. We cannot be sidelined. But I also think that playing too much politics with rule of law issues is not a healthy way for all of us in the European Union. That's why I really hope that we can get this mechanism through as soon as possible.
Sergey and Michael, can we have a short reaction from your side as well? And then we are moving to Mr. Aguilar for final concludings. Thank you.
Thank you, Ilhan. Just very brief. To be honest, I'm not an EPP person, and I'm someone who is quite outspoken on rule of law issues. But I think that it is important to have a differentiated view. And we are watching very closely the situation in Bulgaria with a lot of concern. We had our meetings with the monitoring group, as Vladimir can confirm, with the Justice Minister of Bulgaria, where we discussed the situation with the state prosecutors, etc., etc. So we are critical on that, but I don't see. I want to be fair, and to be honest, I don't see there kind of a systematic push for changing towards a liberal democracy and kind of having a liberal democracy as a model of a new society where all the fundamental rights and independence of judiciary, etc., is basically put to rest. And this is something that I see in many other countries in a more systematic way. It doesn't mean we shouldn't watch Bulgaria close, and we do. But it means that we should also see the differences and all the shadings of various problems. And just very briefly, I know you wanted me to be brief, but sanctions and penalties, what was addressed before. I don't want the new rule of law mechanism is perceived as a penalty, or as we're not going to penalize someone, some country or society. There is no entitlement to getting as much European money as possible. And if you want to be part of the game, then you have to adhere to the whole set of values and principles. And if you don't adhere to Article 2, then it's not a penalty, it's a consequences. They cannot make sure that, for example, the money is spent in the best possible way to benefit all members and all citizens of the country. So it's not in order to penalize Hungary or Poland. This is how they want to look like, how the governments say, we're the victims, you want to penalize, you bad Western Europeans. No, it's part of the package. If you want to be part of the European family in terms of values, then you're getting, of course, the full support. If you don't, then the consequences, we cannot give you the same support and share as everyone else. So it's not about penalties, it's about following through with, for example, transparency issues and how the money is spent, and can we make sure that the courts are independent enough to follow through on that. This is about just a strict application of the main principles of the European Union.
Thank you. Michael, do you want to react? Are you still with us? No, I don't see you. Probably Michael had to do some other committee meetings. But thank you very much, Sergey and Vladimir, for staying until the very end with us. I think the event was broadly covered in Bulgaria, but also in some of other member states. And I want to give a chance to the chair of Libe Committee, Mr. Aguilar, to make his concludings. Are you with us? Can you unmute your micro?
Is it now?
We hear and see you. Yes, Mr. Aguilar.
I was saying thank you, Ilian, and thank you all. Thank you for having me within this conversation. I'm sorry I couldn't make it all the way because I was chairing precisely Libe Committee with the Citizens Initiative on Minority Protection, Minority Rights in the European Union, Citizens Initiative, nonetheless. But I'm happy that I've been given the chance to share some thoughts and some words, just to remind you that there is a story behind this whole thing. Once upon a time, there were the ones called Copenhagen criteria. Those were the criteria agreed in a certain European Council that took place in a rotating Danish presidency. That is why it's got that name, the Copenhagen criteria, namely democratic principles, rule of law, separation of powers, judicial independence, and fundamental rights protected by an independent judiciary. But most importantly, an idea of democracy which does not confine itself to majority rule. No, majority must be also subject to law. And it doesn't suffice to rule by majority, because democracy always takes protection of minorities, which means protection for political pluralism, which means protecting the role of political opposition, which means protecting those who oppose you, those who disagree with you, those who dissent, those who protest, those who rally, those who express freely their minds, trying to overcome that circumstantial majority and be themselves majority. Maybe tomorrow, maybe the day after tomorrow. That's what democracy is about. And those Copenhagen criteria were established as parameters to examine member states on the way to accede to the club, on their way to join the club. And you know what? When states across the European landscape took the initiative to knock on the door of the European Union and ask for membership, they did their homework. So they tried to fulfill all the parameters, all the protocols, and agreed finally that they were given the chance to prove that they have actually behaved democratically and established a democratic legal system in which all of those parameters are to be asserted. But you know what? Throughout the storytelling, we only find that we knew it, but we have found back again that democracy must never be taken for granted. Never. Liberties must be never taken for granted. They're always fragile, and there are always backslidings, and there are always menaces across every corner. Throughout the way, throughout the road, there may be challenges to those parameters. That is why they were finally enshrined when the Lisbon Treaty entered into force, which was the expression of the highest political dimension and even constitutional ambition of the European Union ever. We tried to have some sort of European constitutional treaty. It didn't happen, but finally the whole situation got unblocked with the entry into force of both the Lisbon Treaty and the Charter of Fundamental Rights. And the Lisbon Treaty consists of Treaty of the European Union and Treaty of Functioning. In the Treaty of Functioning, there's an area of liberty, justice, and security which takes mutual trust and mutual recognition on the grounds of a rule of law which is to be taken care of. And in Article 2, there are the values, once called the Copenhagen parameters, that now are enshrined as founding values, binding values for the European Union, namely representative democracy, separation of powers, judicial independence, rights protected by independent judiciary, protection of minorities, and pluralism. And we have seen that throughout the way, there have been so many signals that some member states, including member states of recent accession, were turning the other way, were turning the wrong way, backsliding in democracy. And we have seen an abrupt series of constitutional amendments and initiatives, legislative initiatives, being carried out with the sole support of the majority ruling party, on the grounds that they had the majority to do so. And we have reminded time and again that democracy is not only about ruling by majority, it's respecting the rules of the game, it's respecting laws, respecting procedures, amending procedures, and the right of the minorities to be part of the amending procedures, to be heard of, not simply with contempt of minorities. We have the majority, we overrun every minority outside. We don't even need to listen no more to the minorities. That's not democracy the European way. And that is why throughout this accumulation of evidences that something was going wrong, we set in motion two paths. First path, take those cases seriously. And that is why we had a number of hearings. We heard everybody, both in Hungary and Poland case, everybody. We heard lawyers, judges, public prosecutors, journalists, professors, experts, academics. We heard everybody, even the representatives of the governments concerned, even the relevant ministers of justice of the governments concerned. We heard everybody, just coming to the conclusion that something was really going wrong, that there has been an accumulation of initiatives, legislative, in a short period of time, all of them carried out by the same majority, the majority that supports the ruling party, hearing and listening and paying respect to nobody else, and in contempt at times of the rulings of the constitutional courts of those legal systems, of those national legal systems, and of course contempt of supranational courts, the European Court of Human Rights, but most importantly, the European Court of Justice. And that is the ultimate thing, because the union was meant to be a union of law, a union of law. And the body which is vested with the competence of securing the respect of the law is precisely the European Court of Justice. So the ultimate thing is that a member state that simply shows contempt for the European Court of Justice rulings, and that most regrettably has happened to be the case of those countries that I referred to. And that is why the first path was leading, I mean, inevitably so, to the setting motion of Article 7 as the ultimate thing, with all of the limits and the technicalities that are entailed by this device of the Treaty of the European Union. That was the first path. But there's a second path. The second path is to encounter the usual rhetoric that when we were addressing the situation in a certain member state, the explanation would be that there is a left-wing conspiracy to name and shame that particular member state and to put the blame for ideological and political reason. The whole thing is biased, the whole thing is finger pointing, the whole thing is deviated from the root. Precisely to encounter that kind of rhetoric, we decided that as democracy must not be taken for granted, all of the member states must be subject to a rule of law, democracy, and fundamental rights framework with a policy cycle that creates the framework in which we discuss the situation of fundamental rights within the European Union. We're all familiar with the routine of the plenaries once upon a time in Strasbourg, in which we had this human rights discussion Thursday morning with the High Representative. And we cared about human rights in Yemen. We cared about human rights in Somalia. We cared about human rights in Pakistan. Why shouldn't we care about fundamental rights in the member states of the European Union when they are sometimes subject to situations that we should be discussing and we should be overseeing most carefully. That is precisely the aim of this rule of law, fundamental rights, and democracy mechanism, meant to be binding law, a regulatory European piece of legislation which encompasses all of the member states altogether on a regular basis, on objective parameters and comprehensive of all of the issues involved. So not just confining ourselves to a certain value or to a certain piece of legislation, but comprehensive. And by comprehensive, I mean that part of the discussion has been that member states subject to this examination try to confuse the scope of the discussion with the allegation that this piece of legislation may be equalized to this other piece of legislation in that particular member state. Because the answer must be clear-cut. The answer is that we are not bothered about you, about your situation, because of this particular piece of legislation, but because the amount, the serious, the accumulation, abrupt accumulation in a short period of time of a number of pieces of legislation which are following a strategy. And that strategy is meant not only to overturn the constitutional architecture of democracy in that particular member state, but also to pose a systemic threat to the values. That means a serious breach, a systemic threat of serious breach of the values which are founding of the foundation of the European law. And that is the point we should stick to. And by that token, we must somehow come to terms that all of the member states are subject to this examination on a regular basis from now on. We had Commissioner Reinders presenting his first annual report on fundamental rights, rule of law, and democracy. And of course, the country report was diverted into the public opinion of each and every member state in the worst fashion possible. Just like if the report was only about that particular member state, we have to explain, we members of the European Parliament, that we have a duty to make sure that democracy is not taken for granted, that we are somehow caring of that fragile flower, which is democracy and liberty, rights. And on those grounds, we must assume, we must incorporate that each and every country of us is going to be put to examination too. And there shouldn't be a trouble if the Commission points out that the strategy against corruption is failing to fulfill its objectives in this particular member state, that independence of judiciary has a challenge in the way this particular member state foresees for the nomination of judges or public prosecutors. No trouble with that. We should, or in this particular member state, there have been protests in which hate speech and violence against people who freely exercises their freedoms, like journalists, for instance, are put in on the threat, are put in peril. All of these issues we have to care about from now on a regular basis, and that must be a major field of action and commitment by us members of the Committee of Liberty, Justice and Home Affairs in the first place, because we have the competence on rule of law, fundamental rights, and democracy. And that is why it'll be no surprise that when we see a series of events that are calling for our attention, yes, if there's a majority supporting it, we are to draft a resolution and put it to the vote for the plenary. That's what we did with Bulgaria just recently. We cared about violence against journalists, even assassination of journalists in Malta and in the Czech Republic. No, excuse me, Slovakia. I was extremely concerned about that. We were all extremely concerned about that. So we drafted resolutions on the matter, and we have also been concerned about the massive protests that have been rallying consistently, lasting in time in Bulgaria. 100,000 being mobilized against abuses of power, against mass corruption, and against a very much argued performance of its duties by the Public Prosecutor's Office. All of those issues have to be dealt with. And enlarging the scope, caring about protection of minorities, caring about anti-gypsy rhetoric, caring about gender violence, how the legal system provides for protection for women which are subject to gender violence, how do judges behave when they come to protection of victims of gender violence. The same goes to the regular exercise of freedom of assembly or freedom of speech, or the right to oppose the government without being challenged by arbitrary or excessive prosecutorial criminal actions accepted by the Public Prosecutor's Office. All of these issues are to be discussed regularly from now on, precisely because this is the path that we have adopted by consistent majorities of the Libe Committee in the first place. And that is why SMECA report has been so relevant, because it's clearing the path for this mechanism, European mechanism on fundamental rights, rule of law and democracy, to finally become a regulatory framework which sets forth a so-called policy cycle of examination and interinstitutional dialogue between the Commission providing the annual report, the European Parliament debating the situation of the fundamental rights across the European Union in every member state, no matter what, no matter who is disturbed by this discussion, and the European public we represent, the European citizens we represent, spreading the message that we do care about the fundamentals. If we do care about the fundamentals of the economics, if we do care about the fundamentals of the monetary union, we should care only more so about the fundamentals of the very reason for the European Union to be in the first place, of existence of the European Union, which again, and I finalize, it's about values, principles, binding law, and be ruled by law. The European Union was once the story of a success. We have been in trouble for some years, for sure. We are in trouble. We're not in good shape, and the situation is lasting some years now. But if the European Union was for decades the story of a success, of an appealing success, of an alluring success, it was precisely because it was a union by law. It was instrumented by law. It was done by law. It was set forth by law, and it was ruled by law. And we have to care that that fundamental is never, never, never diminished or lost sight of. So I thank you. I thank you, Ilian Kyurchuk, dear colleague, for this opportunity to put us together to discuss these most fundamental issues. And again, I am sorry that I missed most of the discussion, but I'm happy that I had the chance to share my views with you. Thank you.
No, thank you so much for your valuable contribution, and especially pointing out the issue of minorities and the right to protection of the minorities in European Union, because European Union is not only about majority but also about a minority, and this is the heart of our European democracy. And I want to thank other colleagues as well, particularly in this case Vladimir and Sergey, for making really important points. And I felt enriched, and I think the Bulgarian audience felt enriched as well. Certainly we'll continue our dialogue, our discussion. There's a long way to go when it comes to protection of minorities, of rule of law, of all the fundamentals which are at heart of the European Union. With these words, I want to thank you once again and wish you a good day. And thank you for making time despite your difficult and quite busy agendas.
And thank you, Ilhan.
Thank you, Ilhan. Great.